current 2013 Constitution provides that it can only be amended by the passage of a law approved by the very high special parliamentary majority of 3/4 of the members of Parliament approving, followed by the approval of 3/4 of the total number of registered voters in a national referendum. Mr. Speaker, this makes it one of the hardest constitutions in the world to amend. It seeks an impossible level of participation and consensus, and it was meant to be that way, to preserve forever the handiwork of those who imposed the 2013 Constitution. It is not a mechanism to support popular sovereignty. It is and was deliberately designed to be a measure to defeat the will of the people and to exercise perpetual control over them. Mr. Speaker, excessively high thresholds make a constitution brittle, inflexible, and vulnerable to change by illegal means. Precisely the kind of events that have so troubled this country in the past. The coups of 1987, 2000, and 2006 must never happen again. The last constitution of Fiji that was established by a democratic process was the 1997 Constitution, and it was the product of a review chaired by the former Governor-General of New Zealand, Sir Paul Reeves. And that Constitution, Mr. Speaker, sir, was passed unanimously by the bicameral legislature of Fiji at the time. Section 191 of that Constitution, Mr. Speaker, provided that all amendments to the Constitution had to be passed by both Houses of Parliament, by at least 2/3 of the members of each House. Mr. Speaker, built into the system was the opportunity for consideration. This required that in the ordinary course there be a period of 60 days between the second and third reading of the bill. There was full opportunity for debate prior to the second and third readings and consideration by the relevant standing committee. That committee would be empowered to conduct a process of public consultation. The intention behind this procedure, Mr. Speaker, was to ensure that there was time and opportunity for proper scrutiny and for public wishes to be made known to members of Parliament before they voted on the changes. Mr. Speaker, sir, the report of the Reeves Committee said the following about constitutional reform at page 655. And this, Mr. Speaker, sir, is a copy of the report of the Reeves Commission. At paragraph 20.9, the Reeves Commission said, and I quote, "People recognize, however, that as circumstances change, so some change in the rules may become necessary or desirable. The procedure for constitutional change must strike a balance. It should not make it easy for the legislature or the executive to do away with constitutional limitations on governmental power at their whim. At the same time, it should not impede necessary or desirable change." And it goes on to say, Mr. Speaker, at page 656. Since a constitution should express the broad agreement of the people of a country, the special procedures for its amendment must be such that it cannot be achieved in haste. The procedures must give rise to publicity as well as time for public consideration and debate. They must ensure that all individuals and groups in the community are given the opportunity, either in person or through their representatives, to participate in any discussion and decision on constitutional change. They should also require a significant number of people to consent to any change, either individually or through their representatives. End of quote. Mr. Speaker, in setting the special parliamentary majority at the level of 2/3 rather than 3/4 as proposed in the Constitution Amendment Bill, the Reeves Commission at the time had said that the Commission had borne in mind, and we had used this yardstick as a basis for drafting the amendment bill. The factors that were considered at the time, Mr. Speaker, were the likely future composition of both houses of Parliament, which no longer is relevant, the need to maintain an effective separation of powers and accountability, the need for effective protection of the constitutionally protected rights of the various communities and of individuals, and the need for the popular will to be expressed. There was also the consideration of the need for broad support for any change to the Constitution, as well as finally, Mr. Speaker, the need for some flexibility